So you can go here.
The witness box?
The one over here, you witness box. We'll put you in the witness. So you're
All done?
Oh, good. So I can then, right? I don't have to start at the podium. New media. So immediately to my left is Jack Goodman. Jack is an American communications lawyer who's based in Washington, D.C. He's formerly the Senior Vice President and General Counsel for the National Association of Broadcasters. And he's got a deep knowledge of the U.S. and Canadian industries. And Jack is also here speaking in his personal capacity. Next to him is Peter Miller. Peter is Executive Chair of the Canadian Industry Association Interactive Ontario. He's a lawyer with extensive experience and expertise in both telecommunications and broadcasting. And next to him is Jeff White. Jeff is a sole practitioner. He's here today in his capacity as external counsel for the Canadian Public Interest Advocacy Centre, or PIAC, which is a not-for-profit that advocates on behalf of public and consumer areas, including telecom, broadcasting, and privacy. So to get this started, we're going to be focusing on 3 questions with respect to all of the topics that we're talking about. The first one, in true lawyer fashion, is facts. So how are the U.S. and Canadian policy and regulatory regimes adapting to technological changes and new ways of developing, new ways of delivering content? And Jack is going to talk to the U.S. situation, and Peter will talk to the Canadian situation. The next question is impacts. So what are the impacts of these American and Canadian regimes on U.S. and Canadian industry and consumers? And Jeff will primarily address that. And then we'll look at recommendations, whether and how these regimes should be changed, or the big picture policy questions. And that will just be an open discussion. And depending on timing, hopefully we'll have some time at the end. We're a little bit pressed for time because our last panelist has to fly back right at 3:15. So we'll try and move things really quickly. But if there's any sort of glaring terminology question, then feel free to just shout it out. So to start with, we're going to do a Broadcasting 101, an overview. Jack's going to explain quickly the U.S. policy regime, the key bodies, and key terminology, because we do have some significant differences between the countries. So Jack, will turn it over to you.
Yes, as I said, this is another good example of Churchill's aphorism that the U.S. and Britain, in this case, the U.S. and Canada, are two countries divided by a common language, since almost nothing is referred to in the same way in our 2 regulatory regimes. But basically, U.S. broadcasting and media policy for about the last 4 decades has been focused much more on the development of competition rules instead of content rules. The general policy of both Congress and the FCC has been to encourage growth of new media and new competitors to broadcasters, cable, satellite, now broadband. And from the point of view of traditional broadcasters, these policies have been depressingly successful. The Commission also has a statutory to encourage the growth of diversity of ownership. The Congress took away the one tool it had to actually do that, so it periodically issues a report, and some court tells them they didn't do good enough, and then 3 years later we go through the cycle again. But its specific content concerns in the U.S. are generally limited to 3 areas: children's television, indecency, which in our country does not include violence, and candidate speech. Because we have paid political announcements, the candidates have unique access and discount rights. A major difference between Canada and the U.S. is that both licensing and spectrum regulation in the U.S. for commercial enterprises is handled by one agency, the FCC. The only exception to the broad powers of the FCC are that spectrum for government use is handled by an organization called the National Telecommunications and Information Agency, which is in the Department of Commerce, and obviously they and the FCC have to work together at the margins of the 2 areas of spectrum.
Hey, Peter.
just to pick up on that, as Jack's alluded to, on the economic and the social side, there's a lot of similarities between Canada-U.S., recognizing that we do actually define broadcasting differently, in that in the U.S., the focus is on over-the-air, whereas in Canada, it's over-the-air cable channels and the distribution in a whole coherent system. Again, Jack talked about is that the big difference in Canada is, of course, we have a layer of cultural or content regulation. And for any of you that lived through the FTA cultural exemption and everything that was associated with that, that's something that is a big part of Canada, particularly even more in Quebec than in English Canada. But that too is changing, and in our subsequent questions we'll get into some of the new developments in that area.
Yeah, so Jeff, can you just talk briefly to the impacts of those differences?
I feel like I'm in the witness box here, so I'm hoping to be. I'm hoping to avoid being cross-examined. The impact of those differences. Well, so Jack mentioned how in Canada, in the U.S., spectrum management, broadcasting are governed by one body. In Canada, it's two bodies, and one being a government department that may be more subject to a more direct guidance from the government, as it were, and another more arm's length body called the CRTC, Canadian Radio Television Commission, which is guided by a series of lengthy policy objectives, one under a Telecom Act, which governs, for the purposes of our discussion, the internet side of things, and the Broadcasting Act, which governs the more culturally oriented policy, which Peter was talking about. In terms of consumer impacts, I think what both countries are grappling with right now, and they may be going about it in different ways, is this issue of more and more broadcasting going over what we know as the internet, and via an internet subscription, and moves by large vertically integrated converged entities. And by that I mean companies that own programming assets, they own distribution assets, and they also own telecommunications assets, moves by these large companies to try to basically set up the private lane, so to speak, in the U.S. The same thing has been happening recently in Canada. And the effects of all this are to test these old common law notions of common carriage and non-discrimination, and it hits consumers in the end when there's less competition and rates for either the broadcasting service on the one hand or the telecom service increasing. And that's something consumers in Canada have been concerned about, the increasing rates of broadcasting content.
Okay, so that's a good segue to a proceeding that's ongoing in Canada that's under the purview of the CRTC, which is called the Let's Talk TV proceeding. It's been ongoing since October of 2013. It's still ongoing. The Commission has been issuing decisions over the past month or so sequentially. So we had issue number 4 come down yesterday, and we're waiting for one more decision. And the purpose of the proceeding is really to look at a regulatory framework for television for the next 5 to 10 years. So it's effectively revisiting all of video broadcasting regulation at the same time. And Peter's going to provide us with an overview of that and why it matters. But before that, I'll just identify the topics we're going to hit, because there are so many of them. We're going to pay attention to the ones that are most significant to both countries right now. So the first will be over-the-air television. The second will be new media broadcasting. And the last one, if we have time, will be the relationship between broadcasting and network neutrality. So I'll turn it over to Peter.
Obviously, if you're in Canada, there's been a lot of press on these hearings, and if you're in the U.S. and wanted to look it up, you wouldn't have any difficulties. So I'm not going to get too much into details, but I think, certainly from my own perspective, having worked in this field for a couple of years, having been quite involved in these proceedings, two things stand out for me as very significant. The first is, this is not deregulation, it's re-regulation. In fact, by many measures that are being introduced are going to involve a much greater degree of CRTC than you've ever seen before. So, for example, if you're from Canada, you may have heard that one of the things that's going to be introduced is a small basic at a $25 price cap. Well, price regulation of cable services was disposed of over a decade ago, and here we are with a policy, whether you like it or not, introducing regulation, and that's interesting. The other area in which the pendulum has swung, and again, for anybody that's observed Canadian broadcasting for the last 4 decades, this is quite exceptional, is it's swung away from a preoccupation with Canadian programming towards, if you will, more of a preoccupation over consumer interest. That shift is remarkable for anybody that has followed Canadian broadcasting policy for the last 4 decades, because the Canadian broadcasting system has essentially been built on the premise of having a system that supports Canadian programming. Originally, cable companies were seen as the chosen distribution medium to allow that to happen. Then we introduced competition with other distributors, but the objective always was to maximize support for Canadian programming. We now have a commission that has done the unprecedented. It's actually said, you know what? We've got more than enough money going into Canadian programming. Our problem is how we're spending that money, so we're actually going to allow a diminution of money that's going into Canadian programming. We're going to accept that the money in the system is going to go down. That's a very, very big change. When we discuss some of the other things, we'll see the parallels, again, between the U.S. and Canada remain in areas like news and over-the-air broadcasting, but in these other areas, big change. The one big thing to watch from a U.S. perspective is one of the decisions the Commission has made is about unbundling, the notion that services have to be provided on demand or in small bundles. And of course, Jack can comment on that, but there have been various bills that have been tabled in the U.S. over the years that have always been defeated about breaking up cable bundles. The CRTC has decided to do that, and the rule will also apply to U.S. services coming into Canada. That'll be a very interesting thing to watch, because those services made it clear that they were not necessarily going to agree to that, and understandably, they don't want to accept a precedent in Canada that they're not prepared to accept in the U.S. So how that plays out is going to be very interesting. And I personally believe that if some of these major services choose to withdraw from the Canadian marketplace rather than be subjected to a la carte, the CRTC will blink. Because I think the outcry in Canada, should A&E or AMC pull out, would be so huge that I think the CRTC would blink. But that's a very interesting thing to watch.
Okay, so we're going to turn to over-the-air television, and we're going to talk about 3 key issues. The first one is simultaneous substitution. The second one is a fee for carriage for over-the-air stations that are picked up by TV, cable, and satellite companies. We have different terminology around that, so I'll just ask that Jack and Peter notify you when they're talking about one or the other until you get used to the language. And the 600 megahertz spectrum auction. So Jack, maybe you could give us a quick explanation of these 3 terms, and then we can start talking.
All right. Of course, one of them, as I said in the 2 days ago, I'm stuck explaining your silly rule instead of our silly rule. So I'll give my best, and Peter will tell me I'm wrong on simultaneous substitution. But it's a Canadian regime under which a Canadian outlet, which is carrying American programming from an American source, i.e. a U.S. television station, must, if that same program is authorized on a Canadian outlet, substitute the Canadian version for the American version. So, for example, if a Canadian cable operator carries a U.S. CBS signal and Big Bang Theory is otherwise been authorized in Canada, that the Canadian cable operator must utilize the U.S. version of Big Bang Theory and substitute the Canadian one with the Canadian ads. Is that more or less accurate?
No.
No, okay, good.
Simultaneous substitution in Canada, in my perspective, I mean, in some way that's accurate, but I'll give a different spin on it, is the Canadian equivalent of network non-duplication and Syndex rules. It was just done in a more imaginative way. Obviously, what happens is NBC sells programming rights to Canadian broadcasters. CBS sells programming rights to Canadian broadcasters. It's just they're not affiliates. So the only way those Canadian broadcasters can protect those rights, and obviously territorial rights integrity is a common thing in both Canada and the U.S. It's something that's vital to local markets for local broadcasters to protect their franchise. The only way that can be done in Canada is through a different methodology than network non-duplication and Syndex. And the methodology adopted, and this goes back 30 years, was instead of a blackout, you have a simultaneous substitution. And so in the Canadian context, it's not seen as complete a rights protection measure as and Syndex, because the programming has to be in at the same time, or you can't do the simultaneous substitution. But it is the Canadian methodology, if you will, for protecting local market rights.
And from U.S. broadcasters' perspective, and we'll get into it because we're going to get to fee for carriage, their view is that since their signals are being stolen to begin with by the Canadian outlets without compensation or consent, this is adding insult to injury, that their ads get taken out in addition. And that brings us to fee for carriage, which is known as fee for carriage in Canada and retransmission consent in the U.S. The U.S. in 1992 created a system where every TV station makes a choice, the cable system, and then subsequently the two DBS carriers, a direct broadcast satellite, under which they can choose either must carry, which is a regime where the cable or satellite carrier just must carry the signal of the television station without compensation and without negotiation, or else retransmission consent, which then launches them into a negotiation as to whether the TV station will give its consent to be carried in exchange for whatever type of benefit, reciprocal benefit they may get. They do not necessarily involve cash payments, but most typically in the last few years they have. It's increasingly common. Canada has had a must-carry rule until yesterday, correct?
We still have it.
Oh, but it's about to go, as I understand.
Not for over the air, no.
Okay, not for the air. All right, but the CRTC several years ago adopted a fee for carriage plan, but the Canadian Supreme Court rejected it as beyond the CRT statutory authority. And as a result, one of the consequences of all of that is that U.S. signals are picked up and may be picked up by Canadian cable systems, either the consent of the U.S. station or any compensation, which is an annoyance to my clients in New England. But
I know Jeff's going to want to talk about OTA too, but again, let's go to the similarities.
Peter, just one second. Can we just have a quick overview of what the 600 megahertz is, and then we'll switch into the topic?
Okay. 600 megahertz. After the transition to digital television in both the Canada and the United States, the government reclaimed the 700 megahertz spectrum, which is essentially above channel 51. And in both countries, that has been sold for wireless telephony and broadband use. The argument is that we need 500 more megahertz of spectrum to maintain competitiveness in the wireless world, and in 2012 authorized the FCC to try to clear additional spectrum from the TV band, but to do so on the basis of a voluntary relinquishment by TV stations. And so the Commission is authorized to have a first ever two-way auction where it will both buy spectrum from stations, then repack them into the remaining ones into lower channels, and then sell the resulting cleared spectrum to wireless carriers. The FCC is currently developing the rules for this extraordinarily complex process and hopes to start in 2016. At the end of 2014, Industry Canada issued a consultation, which for Americans, lawyers, is the Canadian equivalent of a notice of proposed rulemaking in our admin law regime, in which it proposed also to have a clearing of the 600 megahertz band and a repacking of stations. But unlike, it did not propose compensation so that TV stations would have to pay for their relocation themselves. In the U.S., they will be paid out of the auction proceeds for any relocation costs. And I think one of the things that is different about the agencies, the two-agency regime, if you read the 600 megahertz consultation, it appears that Industry Canada places a fairly low value on the continuation of over-the-air broadcasting, and I think if you read some of the CRTC decisions in the last month, they have a very different view. So it's the two agencies are somewhat at loggerheads, at least how I perceive it.
Okay, so that takes us to OTA. So Peter, do you want to just finish off that comment, and then maybe we can go into SimSub?
Yeah, I'm going to try and follow all these bouncing balls. I want to step back, just talk about over-the-air broadcasting. Because in a way, you would think it's a technology that's dying. You'd think, why does anyone care? Yet in both countries, I think it's seen to be vital and important. And even the old notion of receiving signals over the air, which seems to many to be anachronistic, is something that actually we're seeing some resurgence in. It never hit the low levels in the U.S. that it did in Canada, but Canada's seen it sort of bounce back arguably to about 8% of the population receiving signals over the air. Why is over-the-air television important? Jeff will speak a little bit about that. But the big difference between Canada and the U.S. is the U.S. has put together a regime that makes local television viable and economically sustainable. So the of rights protection through the measures we've talked about and retransmission consent, and now most recently the fund for relocation and the 600 megahertz band, all things that are happening in the U.S. or happen in the U.S., none of which have happened in Canada, make over-the-air broadcasting in the U.S. viable and over-the-air television in Canada not viable. The only reason over-the-air Canada exists is because we allowed a level of vertical integration so that the owners of the vast majority of over-the-air television stations are telecom companies now. And so essentially they do an internal cross-subsidy and they justify the business as a whole because by having over-the-air and cable channels and infrastructure, the whole works. But that has broken down for any independent stations in Canada, and there's still a handful. And it's going to be an interesting issue because one of my personal views is that it could actually become an election issue because I think stations in Canada could go dark. Small stations in markets, in small markets in Canada, because they've been hanging on by their fingernails and they're not getting any support either from Industry Canada or from the CRTC. So that's going to be a very interesting issue to watch.
I'll make some comments on over the air, I suppose. So yeah, well, I'll try to address the three bouncing balls of fee for carriage, over the air, and simultaneous substitution from the consumer group public interest perspective, if I may, Deborah.
Yeah.
On over the air, yeah, over the air is what my client says is adored, accessible, affordable, auspicious alternative to what are increasingly expensive cable packages in Canada. Now, the broadcast regulator recently took steps to try to address that affordability issue by mandating this specific, this so-called skinny basic, and then unbundling all the channels so consumers can pick and choose the channels they want. And we'll see how that affects, how that shakes out. But like Peter said, over the air is accessible to, I think it's about 97 or 99% of Canadians are transmitter. 95% of Canadians already have access to at least 5 channels. The technology to put a lot of channels over a very limited amount of airspace. But what's happening cross-border is the Industry Canada, the Canadian spectrum regulator, is just following along with what's happening in the U.S., which is a real drive to repurpose what is viewed as spectrum for mobile services, for your smartphone, repurposing it from what's viewed as inefficient spectrum use for your smartphone. Industry Canada is following along, partly because Canada is a much smaller market, and whatever happens in the device ecosystem in the U.S. in terms of what's available, Canada tends to sort of follow on in terms of the gear and the radio equipment, etc. But Canada and U.S. are different in the sense that U.S. wireless providers serve a tremendous amount of tremendously larger populations using a relatively smaller amount of spectrum. Canada has a far smaller population to serve, and there's plenty of spectrum held by the incumbents. So it's a question of what is the policy rationale for foreclosing on over the air, which only about 7% of Canadians currently use, but those who like it a lot. What is the policy rationale behind moving towards more commercial mobile spectrum at a time when, like I say, this is the spectrum could be used for over-the-air broadcasting? So that's issue number one. May I carry on, or
Yeah.
I don't want to talk too much. The substitution issue, that fundamentally, the issue was whether or not Canadian broadcasters could recoup the money they spent on the rights by showing commercials. And the issue reared its head once a year during the Super Bowl, particularly when Canadians would get very angry when they'd be watching the game and at commercial break, Canadian commercials would be put into the feed, and not the amazing popular commercials that you get in the U.S. It was an irritant to the regulator, as far as we can tell. But in being able to have that right to put in your own advertisements, these companies were able to get a return on their investment, which they would then put, you would think, back into the Canadian system, fulfilling all of their Canadian content obligations. So there's a give and a take on that issue, where the consumer interest and the public interest may diverge a bit, but that's something that will be going up to the Court of Appeal. And on the last notion, which is fee for carriage, which is another sort of, it has cross-border connotation, was whether or not the cable companies could, for free, pick up the over-the-air signal and put it into their cable packages without compensating the over-the-air carriers. And there was always an issue there with over-the-air having more difficult economics and so forth. But the cable companies now largely own the over-the-air companies, so there's that cross-subsidy, I think, that Peter, you were referring to. The consumer interest there, though, is ultimately in just not having these fees passed on to consumers, which were estimated to be anywhere from $2 to $10 additionally per month if those charges were going to be imposed. So thankfully, that's not there.
Okay, so maybe we can just go right into what should be changed, and partly that'll be informed by the decisions that would have just come down.
Well, one of the interesting things, and it goes to this whole question of the role of over-the-air television in both countries, is that Canada has up to now protected a very large number of vacant television channels, with the idea that the population of Canada will grow, and that towns that are very small today will be large cities in the future and will need a television station. If Canada maintains that policy, the 600 megahertz transition will be substantially harmed in the U.S. because we protect each other's signals for 400 kilometers in each direction from the border, which is a very long way. And each one of those signals on the Canadian side is protected, and there is just not enough spectrum to do this. So one of the things that Industry Canada has proposed to do as part of this repacking it is proposed is eliminate those channels essentially entirely, I believe. And so there will be, and this is already true, the U.S. gave up its unallocated channels in the digital television transition. So there are no more TV stations in the U.S. ever. That is a really that again is a fairly broad question about Canadian policy, but it impacts the U.S. And the other interesting aspect of this is that Industry Canada's written proposal is that they will do their repacking after the U.S. does its, and because we don't know in the U.S. how much spectrum we're going to clear, and we won't know till the auction. The FCC, however, consistently says Canada is going to go first, which is exactly opposite of what Industry Canada says in writing. And how Canada would go first is a good question, because they say they're going to follow the U.S. band plan, which won't be known until the auction is over. So there's a considerable amount of differential going on at the moment.
Just at a very high level, I got into broadcasting 20 years ago, and one of the first trips I made was to L.A. to meet this gentleman when the U.S.
It was San Francisco.
San Francisco. When they were, had you just got retransmission consent?
Yes, we were on our what we call our Must Carry World Tour.
And I very quickly learned how powerful the NAB is. The CAB, at the time, we were not a bad trade association. It was run by a man by the name of Michael McCabe, that some of you may remember, who was, I think, quite a very effective lobbyist. But the CAB no longer exists. So you contrast the power of the broadcasting lobby in the U.S. with almost a non-existent broadcasting lobby in Canada, because the companies that formed the CAB decided they could go on their own, and quite frankly, their interests are more their telecommunications interests now than their broadcasting interests. So you have broadcast lobby in Canada. So you have effectively no one championing broadcasting policy. That's not helped by the fact that some of you remember fondly that Canada used to have a Department of Communications where issues of telecom and broadcasting were resolved. We now have Industry Canada that deals with telecom and spectrum, and Heritage Canada that deals with broadcasting. Well, no surprise that the Industry Canada department that deals with telecom puts out a consultation document on 600 megahertz that's very pro-telecom and very anti-broadcasting. This is the dilemma. And what's interesting, I think, is how ultimately broadcasting policy in Canada evolves, because the pendulum is now swinging so much away from all the things that used to matter in terms of broadcasting in Canada. I don't know if it's just going to keep going or where they're ultimately might swing back.
Yeah, go ahead. You're done? So we can just move to new media broadcasting?
Sure.
Okay, so very exciting. This is where most of the, I guess, consumer interest in broadcasting issues has certainly come from in Canada, with new services being delivered. Some of them are foreign and some of them are domestic. So perhaps Jack can give us an overview.
Well, the U.S. system is certainly changing, and there are a lot of things going on all at once, and where they're going to end up, no one knows. There have been repeated efforts, I think Peter has mentioned, to have an a la carte regime, for example, put in the U.S. They have been stiffly resisted by the large cable programming networks, and so far successfully. The biggest change last year was a company called Aereo, which, if you don't know it, was a company in New York that sought to take advantage of what it appeared to be a loophole. And it set up a warehouse in Brooklyn with thousands of TV antennas the size of this fingernail, which they claimed would get a TV signal. That was the subject of much dispute. And that if you were an Aereo subscriber and said, I want to watch, again, I'll pick on the Big Bang Theory, and when I watched the Big Bang Theory, it would say, okay, you have that antenna, this antenna is yours for the next half hour. And it would begin recording the Big Bang Theory, and seconds later, if you wanted to watch it almost live, it would transmit it to you over the broadband network to whatever device you had connected, or it would hold it and you could watch it. Aereo took the position that it was not subject to getting either a copyright license or retransmission consent. The networks and other programmers took them to court, and in a decision last spring by the Supreme Court said no, they actually were essentially like a cable operator for all practical purposes, and cable operators had to have a license, but they didn't qualify for the cable compulsory license because they weren't actually a cable system. So therefore, Aereo has now gone out of business. The FCC, in partial response, reopened a proceeding that had started several years ago on whether over-the-top, in other words, providers, people who provide video signals over the internet instead of by dedicated cables, can qualify as a multi-channel video program distributor, which is the U.S. law's technical term for cable systems and DBS systems collectively. And if they are, then they would have certain rights to have programmers negotiate with them. They have a mandatory to at least have good faith negotiations, and it would give them a leg up in the next step, which is they have to get a copyright license in some fashion in order to carry it. Their television signals, which in the U.S. are carried under a compulsory license regime. There are a lot of activity. Dish has announced about a 20-channel system that's actually up now. Apple is announcing, apparently is going to announce a system. Sony announcing a system. There's a lot of activity. Weather and other individual programmers have said they're going to provide their signals directly, like CBS and HBO and Showtime. But one of the questions is each of these costs, and the question is whether fairly quickly you get to paying more for that than you would for cable.
A big issue in lots of different ways to talk about it, but I'm going to talk mostly about the internet dimensions on this. Well, in 1999, the CRTC made a ruling which was to the effect that even though certain audiovisual content provided over the internet might fall under the Broadcasting Act, it would exempt it from licensing. That was the then new media exemption order, which we now refer to as the digital media exemption order. And that precedent has been renewed, if you will, since 1999 up to the present, and the CRTC most recently did it again in ruling out a so-called Netflix tax, the idea that Netflix should be required to contribute in some way to Canadian programming. It's an unfortunate use of the term because there is actual discussion in financial about a real Netflix tax, i.e. an HST, which probably will end up being applied, and I know other jurisdictions around the world are looking at exactly that issue because most domestic jurisdictions didn't anticipate this kind of over-the-top service being provided domestically. More broadly speaking, I mean, when one looks at all of these developments, which certainly are being seen in the U.S. as, in some ways, the end of the cable bundle. So while a regulatory push to end the bundle in the U.S., there may be some strong market pushes to do so. What it all ultimately means for domestic broadcasting, particularly in Canada, is a very interesting question. And of course, no one knows. But it's possible that you could have a coexistence of a sort of traditional broadcasting sphere that has over-the-top elements, and the major broadcasters in Canada have now launched their equivalents to Netflix. Bell Canada's launched a service called Crave TV that relies primarily on HBO content, and Rogers and Shaw have launched a service called Show Me that has a lot of content, including some stuff from Amazon Prime, movies, etc. So it's possible we will have, in a sense, some over-the-top players like Netflix operating in Canada, but many other players operating within what we would have called the system. It's possible it'll significantly change. My background's in technology, and one of the things that I've found interesting on watching the evolution of the internet is how, many of you remember 10 or 20 years ago, the word was, it's impossible to regulate the internet. I mean, I think we all heard that. People will say, well, it crosses boundaries, borders, it can't be. Well, a lot of this conference, the previous sessions have been talking about regulating the internet, and the FCC, in its Title II regulation decision, has decided to regulate the internet for the purposes of providing net neutrality. So we've passed that. But ultimately, where the internet goes is going to be an interesting issue. And it's not just going to be a Canada-U.S. issue. It's, of course, going to be an international one. France has raised concerns, as many of you know, in terms of Netflix entry into that market and not supporting domestic content. So that is going to be an interesting thing to watch.
Just echoing a bit of what Jack and Peter had to say, two of the major, a lot of the policy and regulatory debate and some of the competitive skirmishes that are going on in Canada right now are results of the impact of over-the-top internet broadcasting services and their availability to Canadians. So the current stat, or is that 4 in 10 Canadians consume broadcasting over an internet connection, and about 1 in every Canadians has a Netflix subscription. So the question has been, and the business issue by the vertically integrated broadcasting telecom companies has been, well, how are we going to respond to this? And in their response, there have been some consumer issues. So the first attempt in the launching of TV Everywhere offerings, which is to being able to watch their broadcasting content on your tablet or your smartphone. The first attempt was to offer their wireless subscribers data discounts on what they were watching. So that what the effect of that was, and this is documented in evidence, is that it was the data to watch the broadcaster's content through their mobile connection was about 800% cheaper than if you were watching the exact same content but through a different provider. So there was that sort of discrimination going on, and a university student brought a complaint to the CRTC, and then my client brought a similar complaint with different arguments about 2 other companies that were doing this. And ultimately, the broadcast and telecom regulator said, no, this is a violation. This is a violation of effectively the net neutrality, violation of your duty as a common carrier. The second case relates to what Peter was saying, which is the competitive response in Canada to what's happening with Netflix. And these are these 2 services, Crave TV and Show Me. And what's happened there is that the broadcasters have tied your subscription to these services to either the old cable model or to an internet service subscription from the actual service provider. So they're not quite like Netflix, for example, or Apple TV or whatever, where all you need is an internet connection. They're actually trying to funnel people back to either the old legacy system or to their internet services. And so my client, a public interest group and a consumers group, challenged this before the CRTC recently. And the CRTC actually, they returned the application announcing this new policy where they're saying, no, these appear to be operating within under clear rules, but we're creating this new hybrid category of sort of online broadcasting service that you can tie to the closed system, closed cable system, as long as everyone can get it online. So there's some complexities there, and there's a notice of proposed rulemaking or notice of consultation there. But effectively, what all of this amounts to, from a consumer's perspective, is an exercise of market power, and one that appears to be designed to raise rates or keep these companies whole from losses that they may be suffering on one side of the business and making it whole on the other side of the business. Losses on the broadcasting side, perhaps being made up on the internet side, and so forth.
Yeah, well, I think actually one of the things that we should talk about is the idea that we are going to move from either a broadcast or cable model, both of which are point to multi-point distribution, to essentially an internet model for distributing video, which is a point-to-point distribution, has infrastructure implications that really haven't been addressed yet. Right now, Netflix, which serves probably 4 to 6 million people a day, occupies 25 to 30% of the internet capacity of the United States in the evenings. Literally, it's dominates the entire internet. And that's a fairly small number of people over a fairly small number of programs. If you instead would take, say, March Madness, and you put that into that model, the internet breaks down in the United States. And so the costs of essentially building much fatter pipes to do this are something that people are do. And the other interesting question, which I don't think we have any notion of what it is, there are people like Sony, like Dish, who believe that they can create essentially a multi-channel over-the-top service. It has occurred to me that it's not clear why, say, for example, CBS would be willing to share any of its over-the-top revenue with an aggregator like that when it can do exactly the same thing and just have CBS Now and go directly to consumers, and consumers will buy just directly from the programmer who wants. So I think there are a lot of very open questions as to what's going to happen in this space.
If I may, I think the infrastructure issue is a very interesting one with comparative implications, because to the extent that more and more broadcasting is being consumed online, and to the extent that the internet delivery platform is viewed as the way of the future, you have to look at what the 2 different countries are doing in terms of investing in broadband and in terms of what the government, the leadership is saying in terms of what the goals need to be. So in the U.S., there's the National Broadband Plan, which is far more ambitious in terms of its goals for access, availability, and affordability for everyone having that connection. Canada's looked at it a couple of years ago and set a much more modest aspirational target, and the funding is comparatively far less for reaching that universal broadband target. But if you get to that universal broadband target, you could make the argument, as one or at least one other academic has argued, that there's a cross elasticity there between the over-the-air signal and the higher, the more efficient broadband channel for delivering content. But there's always that, you'll always hear from my clients, there's always an affordability issue. And that's why as it stands right now, given some access and affordability issues on the internet side in Canada, over the air is a great alternative and a free one, and it's one that can rein in some of the market abuses of the companies.
I wear a couple of hats in these debates, so I'm going to put on my Interactive Ontario hat. Interactive trade association that represents digital media companies in Ontario, and I'm just the pro bono chair of the board. But what's refreshing about the IDM sector is a couple of things. First of all, it is digital content. It is digital content that's usually primarily produced for an international marketplace right out of the gate. Canada has some success these days with exports of our top film and TV programming. There have been notable examples of Canadian dramas showing up on U.S. networks, and that's something that I can tell you has been a big source of pride for Canadian producers. But in the IDM area, it's a very different business. It's very different in terms of its international exports. It's very different in terms of how markets are accessed, because of course IDM takes full advantage of everything the internet offers in terms of ability to access markets around the world. Mobile apps, for example, didn't exist 5 years ago, and now there's something like a $53 billion global opportunity slated to grow to something like $143 billion in the next 3 years. So it's a great sector, and in Canada, Ontario in particular, a lot of small entrepreneurial companies in it, which from a young person's perspective is huge, because all these companies are run by young people. The entrepreneurial nature of these kids, and I'm sorry, I'm going to say kids because they feel like kids to me, but is extraordinary. And it's nice to see that part of the sector benefiting so much from the platforms and the technologies that, of course, all originated here in the United States.
So I'm just concerned about the time. We've got 15 minutes left, so maybe before we open up to questions, just to touch again on internet neutrality. So there have been a couple of things mentioned here, but do any of you have anything additional to add about that, about either implications or specific instances we haven't already talked about?
The only thing I'll say about net neutrality is, remember my comment earlier about everybody saying 10 to 15 years ago that the internet can't be regulated. It's a concept that has some nuance to it that I think sometimes gets lost in debate. Given the numbers that Jack, for example, mentioned about how much bandwidth is used by Netflix, the impact of net neutrality means that non-Netflix subscribers are subsidizing those people that are watching Netflix. Because we have to remember the business model of Netflix has two wonderful ingredients. You push the cost of transmission to someone else, and 90% of your content is library that someone else has paid for. It's not a sustainable business model for television going forward, which is why I happen to be more of an optimist in terms of the old business models and the old companies finding a way to survive and take advantage of the internet as well as conventional delivery models.
Interesting, the Wall Street Journal this morning has an article in which they report that several Netflix, Sony, and several of the other companies that are proposing these over-the-top services are approaching the broadband companies to have them characterize these as managed services, which is an exception under the new rules, which essentially allows a faster transmission path. I think if they do that, all hell will break loose, because the people who supported the Commission's rules, that is exactly what they said should not happen. So it's there are going to be a lot of battles still to come on this. And frankly, if I were a young lawyer, this would be a great career path.
And drones. I thought we said drones.
Drones are good too. Yes. Yeah.
Jeff?
I would argue that the internet certainly can be regulated as a utility that should be governed by common It is essential to everyone's livelihood, and there's no dispute about that. It can be regulated, it must be regulated, and the fact that I think all of us have talked about Netflix as the example of what's happening, so much happening as a reaction to it on the business side, but also on the regulatory side in Canada, just to me highlights why you need to preserve net neutrality, because its preservation enables that next competitor to Netflix to evolve. But if you start allowing the dedicated transition lanes and the fast lanes and the slow lanes, you start preserving internet monopolies, which we know of a couple. On the search side, for example, on the social media side. So I think it's very important to preserve, and governments are increasingly understanding that. So I think net neutrality on both sides of the border is something very much in debate, but I think that the leadership is recognizing it as that public utility.
And Jeff, to put those two issues together, after you've said that, when you walk outside, keep your eye out for a Verizon attack drone.
So now we should probably open it up to questions. Does anyone have a question?
I loved your comment, Peter, about how this would be a really good area for law students to take up, because we actually do have a course in media law at UWO, and I found there aren't a lot of law schools that are really regularly offering that course, which is a very self-serving thing for me to say. Jeff and Peter mostly, this is a Canadian policy question. There's been a bit of commentary criticizing the overall telecommunications and broadcasting regime in Canada as just being not currently up to date. It was brought in the 80s and the 90s under a separate Broadcasting Act, separate Telecommunications Act. Technology has changed so much since then, and there have been calls for unifying, creating one unified regulatory regime. And I'm just wondering if you had any comments about that.
Actually, I do. I've written papers on. Good legislative drafting has the principle of technological neutrality, and I happen to think that both the Broadcasting Act, which was 1991, and the Telecom Act, which was 2006, is that right, exhibit those qualities. The Broadcasting Act in particular, because the whole notion of the Broadcasting Act cast a wide net as to what might be considered broadcasting going forward. Remember, we moved in the 70s from thinking of broadcasting as just being over the air to bringing cable channels, what we call specialty services, into the rubric of broadcasting. So the drafters of the Broadcasting Act wanted to make sure that whether broadcasting was delivered by Hertzian waves or wires or the internet, the regulator had the opportunity, if it was in the public interest, to choose to regulate it. What the regulator has done is said, okay, even though the stuff on the internet is technically broadcasting, given the way the Broadcasting Act is defined, we're going to exempt it from regulation. So I think it stood the test of time, and I see no urgency to change it, because I policy debate as to what we want, what we think is broadcasting, has to precede making the legislative changes. In terms of a joint act, interesting, those on all sides of the fence are opposed to it. The biggest proponent was the former chair of the CRTC, Conrad von Finkenstein. I never did understand why he wanted it, but Timothy Denton, who is a former CRTC commissioner and on the opposite side of most issues with me, doesn't agree with the Communications Act. Peter Grant doesn't agree with the Communications Act. None of the people that really have looked at it see any particular value. There is a very clear separation of broadcasting and telecommunications, if you will. Broadcasting is a subsegment of telecommunications with particular needs. Only one act applies at a time, and I wouldn't advocate any change immediately. Yes, longer term, 10 years maybe, but not now.
My client has in the past advocated for a merger of the acts. Not necessarily because one act will necessarily solve the process, but it's the exercise of looking at what the problems are, and there seems to be a growing problem with the two acts colliding and with broadcasting being increasingly delivered over telecom service. And the result of that is the regulator seems to be struggling to keep the two acts separate from each other, even though the two speak to each other, and issuing decisions which say, on the one hand, you can be exclusive, you can have certain content exclusives online. On the other hand, or you can tie your subscription to an OTT service to the cable model, and vice versa. There's a growing discord as far as I can tell, which, and I wouldn't be the first of these of the so-called wise men and wise women to call for a policy review to at least discuss the issue, whether or not the merged act at the end of the day is the right way to go. I don't know, but it certainly needs to be from a consolidated approach.
I think, Jack, you touched on this a bit. I'd be curious for everybody's views on yesterday's CRTC decision, a little more in depth, particularly on the pick and pay regime with channels, more in depth on how the content providers in the U.S. will react. Jack, you said that maybe they'll just threaten to pull that the CRTC might blink, but isn't there a pretty steady stream that they get from doing business in Canada? So just speculating on what might come in the next year or so from that.
Actually, Peter said that, but
Okay,
I'll take responsibility because I don't disagree with it. Several of the U.S., particularly the larger pay cable channels, and the one in particular that comes to mind is ESPN, has been very adamant. It will not sign a deal in which it is not in the U.S. on the expanded basic, basically the to almost everybody. It will not allow itself to be put on a pay tier. It will not allow itself to be provided on an a la carte basis. And its business model is very much dependent on that arrangement because as a result, probably 98+% of all cable subscribers pay $6, $7, whatever dollars a month it is that ESPN costs, and that generates the revenues plus the advertising revenues that ESPN uses to buy what is increasingly expensive sports programming. If that model changes, then ESPN's economic model must change and perhaps change radically and perhaps vastly increase its cost. If it becomes an optional service, it may have to go to $15 a month, and then of course that depresses its market share even further. So one of the questions that I think any U.S. or any other operator will have to say is, if I can't sell my service on the way I believe makes sense to me, is the revenue from Canada worth the harm that I might do for myself by, if I agree to do this in Canada, will that follow me to the U.S.? Maybe that's going to happen anyway, but will it make it harder for me to resist? And if it is going to follow me to the U.S., is the revenue from Canada worth the lost revenue that I could see coming in the U.S.? I don't know the answer to that, and so we'll see.
And just to add to that, and you know, know what these services will do. Now, just so people know, in Canada, there's only a limited number of U.S. services that are directly into the country. So A&E is one, AMC is one, but other services have partnerships with Canadian equivalents. So the comedy channel or network is not directly into Canada. It has a deal with the Canadian equivalent and so on and so forth. But to me, it's just a matter of leverage and consequence. Some of the U.S. providers, I think it was AMC and Viacom, came to the CRTC hearing. That doesn't happen very often. And the submissions were very respectful. No one was threatening. But the message was pretty clear, and Jack's laid it out. So I'm AMC. If that gets pulled from the system, I can tell you it'll be back on in a week. I can guarantee you it'll be back on in a week, because the complaints will be so extraordinary that someone will blink. So what's the consequence of AMC saying, no, I'm pulling it? I don't think there's any consequence at all. And I think they'd win it. I think they'd win the game of chicken. So, that's just my view, but I'm very interested to see how this is going to play out.
Anyone else?
Thank you very much to the panel. We're unusually for us running right on time here. We're at 3:15. We actually have scheduled a half-hour break, but I just want to show of hands. Would people prefer to keep chugging along with maybe a 15-minute break instead? Show of hands on that. All right, 15 minutes it is. 3:30. We will.